What you need to know about how a disability insurance policy or plan will use active at work language in their policy or plan to deny your ERISA disability claim. Did you know that there are different policy terms and plans that disability carriers will use in an effort to deny a legitimate claim? And one of the most common games they'll play is looking at a policy term called active employment. Now, many times this clause will say that you have to be working at least 30 hours weekly on a regular basis to maintain coverage. And they may also define disability as the inability to perform one or more of the essential duties of your occupation. It's crucial that you also look at that definition, and that can be defined to mean a duty that was substantial and not incidental, fundamental and inherent to the occupation, that couldn't be reasonably omitted or changed. Now, these are crucial terms that are in a policy. And what's also important here is that there are times in a disability policy when it will say that coverage ends when you cease to be a full-time employee. So we're going to kind of set the parameters here in a case that illustrates these difficulties. On the one hand, you have to be actively employed, working at least 30 hours per week. And on the other hand, you have to be a full-time employee to maintain that coverage. And once you are no longer a full-time employee, you lose the coverage. So I'm going to tell you the story of a case involving a woman who in 2017 began experiencing back pain, and she reported that pain to her employer. 2 years later, in December of 2019, she gave her employer a doctor's note asking that she be allowed to work only 30 hours per week. Her employer denied that request, and she continued to work full-time. Now, she worked full-time for another 6 months until on June 30, 2020, she gave 2 weeks' notice of her resignation. This woman worked full-time through her final date of employment. On June 17, 2017, she resigned, she filed her claim, and Hartford denied that claim. Well, what was their reasoning? They said, look, up until the point you submitted the claim, you were working full-time and you were performing the essential duties of your job as a dental hygienist. So you're not disabled. She appealed and she pointed out that she had worked full-time despite the significant physical challenges caused by her disabling back problems and without accommodation. Ultimately, this case ends up in federal court. So what does the judge do with this policy language? It was a catch-22. Federal Judge O'Hare ruled that this particular woman, who was covered by a Hartford policy, was entitled to her benefits. And he said, look, if the defendant could lawfully deny benefits based on the fact that they were working full-time and were per se not disabled, then no employee could potentially be disabled unless they reduced their hours or they left the employment. Reducing hours or leaving, however, could have the effect of impacting coverage, because as I said, under 30, there was no coverage, and if they left active employment, they were entitled to benefits. And the court said, look, this isn't hypothetical, this isn't speculative, because it was happening to this person, and this person was now in a catch-22. You continue to work full-time and never be able to prove that you're disabled under the policy, or stop work and lose coverage. It's not necessarily an either or. And under this theory, advanced by Hartford, no employee could qualify for disability benefits. And the court said, look, that's not how we're going to interpret this policy. The judge got the flaws in Hartford's alleged logic and noted that there is no case law across the United States that establishes that a claims administrator or a carrier can only rely on attendance or the ability to work to determine whether or not a person is disabled. The case law requires that you look at the totality of the circumstances, that you evaluate the medical evidence that's being presented. And using job attendance is only one of the many considerations in determining whether or not a person meets the definition of disability and are entitled to their disability benefits. It can't be the only criteria. Obviously, the court suggested that she was struggling to work despite her disabilities and despite the fact that her employer denied her request for accommodations. And he felt that that actually supported her claim for disability benefits. You can see how disability carriers will purposely misinterpret or misapply terms of the disability policy to deny benefits. If that's happening to you, call me today at 727-894-3188 for a complimentary consultation. I can help you get the disability benefits you deserve regardless of where you live in the United States.